and help you with in-home care tasks that you need so that you can stay in your home with your full dignity and connection to community rather than enter an institution like a nursing home where it's presumably a lot less comfortable for you, which is also more expensive for the state. So the whole question is, how do we decide how much care somebody needs in order to stay out of a nursing home to meet their care needs? Um, and so what Inter-RAI claims to be able to do is to standardize that, right? And say, well, if somebody needs this level of care, um, or has these characteristics in Arkansas, that should be the same as somebody who has these characteristics in DC, which should be the same as somebody who has these characteristics in Belgium and and in Ethiopia. And Inter-RAI is a worldwide research consortium that's focused on trying to standardize measurement. Now, what happened, there's a lot of complexity that goes into that. But Arkansas adapted Inter-RAI's assessment tool to evaluate people on this Medicaid program. They moved away from a tool that involved nurse discretion. So nurses, it used to be that a nurse, an RN, would go out, interview somebody using a paper form, kind of decide based on their conditions and their functional limitations, how much help they needed, and give somebody a number of hours per day. The maximum was 8 hours per day. I should note that that is not enough care for somebody with cerebral palsy or quadriplegia or various other conditions. But if it's distributed just right and everything lines up, 3 hours in the morning and 3 hours in the afternoon and 2 hours right before bed, people were able to maintain their independence. DC has always offered more hours than that. New York had at one point, I think, 24 hours a day being possible. So other places are more generous. That's a state-specific decision. That's how it used to work in Arkansas. Arkansas adopts the Inter-RAI tool, and then they adopt an algorithm that takes the data from this Inter-RAI tool and then determines kind of your relative care. When that happened, it was just mass devastation for clients. People who formerly were getting 8 hours a day were now getting 4 or 5 in the best case scenario. What that meant in human terms is people lying in their own waste. It meant people developing bed sores from not being able to be turned. It meant being totally shut in and shut out of any sort of community interaction. Horrific stuff. People who were scared to take a drink of water after 6 p.m. at night because it meant they would be sitting in wet clothing until their care aide came the next morning at 8 or 9. Horrific suffering. Those folks called legal aid. We were wondering what is going on here. Like, we had had some problems with this program in the couple of years before, but maybe a dozen or two cases in 2 years. I think we got a dozen cases by the end of January 2016 when it was implemented on January 1st. So we start looking at it. The way folks know an algorithm is happening is, or the way that we discern that, is that clients are being told by the nurses, the computer's making me do this, or the computer is doing this. It's not me, it's the computer. And nobody knew really what that meant. And so we heard that, started looking into it, realized an algorithm was at work, and then started the process of fighting it. And that would be a 3-year campaign. Initially, we started with litigation in federal court premised on due process. To do that, I actually learned the algorithm, and to the point where if you gave me somebody's assessment, I could tell you where they would come out after being run through the algorithm. We learned that there were errors in the algorithm. We learned that the data that the state had relied on to decide how many hours of care you were going to get was faulty and had been lost. And that the consultants who they'd hired to have it, which was McKinsey, no longer possessed it or couldn't access it. Horrific stuff. Nobody at the state agency could explain how the algorithm worked. Nobody cared to know. They didn't run any projections about how it was going to impact people. I mean, just ridiculous. We ended up winning our first federal suit, which was premised on due process, to get better notice. The state put a pause on cuts for a few months while they tried to figure that out. We'd hoped that that would chasten them and make them reasonable to discuss bigger program changes. They were not chastened. So a few months later, we sued them in state court on Administrative Procedures Act grounds, that this was an unpromulgated rule. We were successful in getting a preliminary injunction. State Supreme Court affirmed, went to judgment on the merits. We won, invalidated the whole algorithm. The state tried to adopt it as an emergency. We got them held in contempt, and referred for professional discipline, which was fun. And then the state, while we were doing all this litigation, we were also very conscientious about building public education campaigns and community activation so that there would be additional sources of pressure on the state. We had some amazing clients or people in our client community who stepped up, were advocating vigorously, and convinced the legislature to abandon it as well. So between the courts and the legislature, we kind of condemned this thing to the dustbin of Arkansas history, though clearly these things are spreading everywhere else. The state replaced it with a new system. The new system had similar problems. And then more recently, we sued the state, pierced the qualified immunity of state officials. So we sued them in their individual capacities to be able to get money damages. We succeeded. And we just got a $500,000 settlement for our 3 plaintiffs, along with systemic relief from that. So that's kind of the Medicaid saga in a nutshell. We've also done some work on getting access to algorithms under our state's Freedom of Information Act and some other things here and there.
Great, thanks, Kevin. I'm fascinated by the work in litigation in this space, and I know particularly there's some common themes like them pointing the finger at, it's not us, it's the computer, it's the AI making us do this. And I know, Sam, you've seen that in some of your work. Can you talk about some of the litigation you've brought?
Yeah, sure. So thanks to everyone for your contribution so far. I think a lot of what I'm going to cover is going to sound similar to how Grant had described Rent Grow, but it deals with another couple of tenant screening agencies. So when I was at Cohen Milstein, I was involved in 2 cases that are relevant to the discussion. And the first case informed the second pretty heavily. So the first was Connecticut Fair Housing Center versus CoreLogic Rental Property Solution. This is a federal case in the District of Connecticut. We went to trial last October. No verdict yet, no decision yet, but fingers crossed it'll come soon. We'll see what happens. But in that case, it was an action challenging, the use of a tenant screening algorithm used by SafeRent that evaluated people's criminal histories and claimed that it would then, be predictive of their ability to be a good renter. So I think that the best way to explain the case is to share the story of the named plaintiff. So Mikhail Arroyo was a young man who suffered a traumatic brain injury. And so his mother, Carmen, became his legal guardian and wanted Mikhail to move in with her into her apartment. At the time, she was in a 1-bedroom, so she applied to be in a 2-bedroom. Her landlord says, fine, that's great, but Mikhail needs to go through this screening program through SafeRent. And, SafeRent offers all these different products. He has to be going through all these screening systems. We'll let you know what happens, or SafeRent will let you know what happens. Mikhail's denied, and it's unclear on the face of the paperwork why he's denied. If it's a credit issue, if it's a criminal issue, what's going on? Meanwhile, Mikhail's in the hospital. He ends up having to be discharged to a nursing home, which was an entirely inappropriate placement for his capacities when he could have lived at home with support from his mom. He didn't even need more in-home behavioral supports or in-home aid. It really was just he needed to be able to live with his mother to make progress because she was providing him individualized care that he wasn't getting in a congregate setting. Lo and behold, it took Carmen over a year to figure out what the issue was. So first she thought it was a credit issue and was going to find out what it was, pay off the bill, figure out what was going on. Eventually, she realizes that while they live in Connecticut, Mikhail had visited his grandparents in Pennsylvania, and he had a really, really low pending charge. He had been charged with the equivalent of a traffic citation, but it was a non-traffic citation related to petty theft. So she was able to get the charge dismissed. Mikhail was able to move in with her. It took over a year and a half. And so the case was challenging a few things. First, it was challenging this, criminal screening background overall, right? The idea that SafeRent used a product, and all of this is publicly available, thankfully, because the trial was last year. So if you want to take a look at some of these documents or a sneak peek at some of the more proprietary stuff, I'd encourage you to check it out because I think it's really interesting to see the marketing materials for this sort of material, and it's not super commonly available. But that's just to say, there is a background product that would look through someone's criminal history. They would take raw data, which had a lot of different errors, And then someone at CoreLogic would code this raw data to be relating to some sort of, disposition of a crime. And then they ran that through their proprietary product, which basically set a look back period for, how long would you consider before you would auto deny someone from being able to, rent. So in this particular instance, and in many of the instances that, we had discovered in the context of this litigation, the defaults for this grid product were 99 years for any conviction and 7 years for any arrest. So even if you had done something that was entirely in your past, that wasn't predictive of any sort of, behavior that you could have as a tenant, either with regards to your ability to pay rent or with, you being a safe person to rent to, there just wasn't any way to go around the system. And there were other claims involved in the case that I think draws a nice through line based on this previous discussion around transparency, right? The idea that Carmen had to go through all of this rigmarole, and she eventually went to Connecticut Fair Housing Center, who is an organizational plaintiff in the case along with Carmen. And through a lot of really diligent work, they were finally able to figure out what happened because Carmen decided to drive herself to a courthouse in Pennsylvania and ask if they had any records available. And it really just highlights how difficult it is to bring these claims when you don't know if you have a claim or not. So there were different allegations in that case related to the Fair Credit Reporting Act as well. So we'll see what ends up happening there. The other case that I was involved in more primarily at the front end as opposed to the back end was a Lewis versus Safe Rent, which is a District of Massachusetts case on behalf of Section 8 voucher holders. And they're challenging another screening mechanism. Safe Rent Solutions was formerly CoreLogic Rental Property Solutions. So same company. We were able to use a lot of what we discovered in the first case in informing our second complaint. And it was challenging what Safe Rent describes as their Safe Rent score. So they decide to give an applicant for an apartment a number between 250 and 850. It looks a lot like a credit score. It isn't a credit score, but it considers credit information among eviction information and other sorts of different pooling from publicly available data, along with things that, they say inform their secret sauce for being able to determine if someone's going to be a good renter or not. And Safe Rent goes as far as to say, look, someone that we say has a score of 700 is going to be a better renter than someone who has a score of 690. But all of those considerations aren't necessarily tested. They aren't proven, right? You take a lot of different inputs into an algorithm and you try to machine learn and predict what's going to make you pop out good renters or better renters. And in the allegations in that case in particular, there are so many benefits that Section 8 voucher holders have in terms of their housing security. And there's so much less of a risk for landlords to rent to. Statistically speaking, we know that they stay in their apartments much, much longer than folks who aren't on vouchers. We know that they're more likely to have a stable source of payment because the Public Housing Authority is going to be able to cover the rent in circumstances that another sort of tenant wouldn't have that backdrop in. And so the allegations in that case are saying, look, not only is this race discrimination, which is the same disparate impact FHA claims as the prior case, but also it's source of income discrimination, which is a novel theory that's supported by Massachusetts state law. So that just arrived a motion to dismiss a few months ago. And so that was exciting news to hear after I jumped ship to AARP Foundation. But we'll see what happens going forward. But I think the takeaways in terms of litigation overall that I would share are, first of all, there are disparate impact theories that I think are really colorable as it relates to employment and housing a lot in this space. I've written some on Law 360 related to employment AI as opposed to housing AI. Legally speaking, they function really similar after the Supreme Court's Inclusive Communities decision from 2015, which allows for FHA disparate impact claims following Title VII disparate impact structures. But also just that there's so much of the screening out there that folks just really don't know about. And I think that for people who are trying to figure out what's the next step, how do we, tackle the beast? I think the first step is really understanding what's going on.
Can I just add there, the prevalence of algorithms was something that really astounded me personally when my office started looking into these tools. And just some of the statistics that we've used are that nearly 55% of human resource professionals use predictive algorithms in their hiring process. At least 90% of US hospitals have some kind of algorithmic strategy woven into their business models. Not all of that is patient facing, thank goodness, but you have to bet that a fair amount of it is, especially given the example that Kevin highlighted about determining and rationing care based on a computer prediction. And then more than 90% of lending decisions are based on credit scoring that is built in such a way as to leave out good indicators of a reliable payment, such as rental payments. And this depresses the credit scores of lower income individuals who are less likely to own their own homes, but have made rent payments on time for years and years and years. And these are just some of the examples. There are some more egregious ones, and I'll just point out one. I know this is part 2 of the conversation, and you probably already spent a lot of part 1 just enumerating really offensive examples, but there's a medical appointment scheduling algorithm that tells clinics they should double book Black patients in the same appointment slot based on the belief or the sort of data-driven dictate that these are folks who are not going to show up for their appointments. And then it creates a vicious cycle where if you go to your appointment and they make you wait 40 minutes, 50 minutes, an hour, then you're going to show up late next time. And then the algorithm is going to say, this is a person who shows up late, let's triple book him. And it just goes on to really, really tinge and influence the quality of care that someone gets. And so these are just some of the other areas of our lives that are influenced by these sort of ghosts in the machine that we can't always see, but thankfully through the work of the folks that you see on this call is becoming much more manifest, and the Stop Discrimination by Algorithms Act would force a lot of this out into the open as well.
Thank you so much for that, Kate. And I think that's a great segue because, well, first off, I wanted to stop and ask, did anybody have any questions about anything that we discussed? You can feel free to either come off mute or put it into the chat. And if there are no questions, I wanted to move into, because, the hope of this ultimately is to try to find either legislative fixes or litigation fixes to kind of patch some of this stuff to protect people's rights. So Grant, if you wouldn't mind maybe discussing a little bit about the SDAA, and Kate, obviously, to the extent that you feel like you're able to, you could always chime in. But a few things that I wanted to discuss was, Grant, in your reading of the SDAA, did you notice whether or not government agencies under DC were covered under that? And also, did you notice that there was a private right of action? And what do you think about some of Upturn's commentary during the testimony they gave about allowing other people, other experts to kind of view the data that DCAG is theorizing to collect? I know that's a lot, so
no, it's meaty. I'm excited to jump in.
Sure.
I'll highlight some of the kind of very top level highlights of the SDAA, and then would love to discuss the private right of action and the sort of independent transparency and auditing discussion. The SDAA is by and far one of the better bills we've seen on AI discrimination. There are more that come out every month, but still very few that have actually passed. So we're obviously very much still in the phase of trying to figure out how to get some of these protections into law. Some of the highlights that I really do enjoy from the SDAA, first and foremost, it has a really strong definition of algorithm. Often we find in practice, in litigation, in administrative proceedings, the easiest out for a company is to claim that their product isn't actually covered by the Act. We see that in the EU right now with the EU AI Act, which has a kind of risk-based threshold where if you have a certain type of AI system, you need to do a lot more testing and evaluation than you do if you have a certain other type. And a lot of companies are pushing back saying, no, we're not this sensitive type of AI system. We're just a general easygoing AI system. So just give us the minimum requirements under the law and let us move on. In a similar way, a definition that's too restrictive, that's too limited, that's too focused on how the technology works today, it can miss a lot of what we see new AI systems kind of popping up and the types of harms that they're causing. So the SDA's definition, I think, is fairly strong. And it also, I think, very importantly includes both an enforcement provision for the Attorney General's office and a private enforcement provision for a private right of action. This overlapping enforcement mechanism, I think, is one of the best ways we have of both capturing when AI discrimination occurs and also effectively stopping it. So a private right of action is one of the strongest things that I think that we can have in a legislative solution. It's in a few bills, including one out of New York for employment discrimination algorithms specifically. And it's great, one, because it gets past a lot of the resource constraints that we see government enforcement often butting heads with. And it also empowers people who have been harmed by these systems to pursue litigation directly. Pressure of litigation is an important tool in making sure that AI developers are developing and using AI responsibly. And so that's kind of my general point on the private right of action.
Is that something real quick? And I'm happy to hold this for later. I was just wondering if I could make a comment real quick on private right of action generally. For practicing lawyers who in particular represent low-income clients with public benefits issues and anything justice oriented, federal jurisprudence is restricting the right to come to court under existing statutory frameworks. So like right now, if you want to sue under the Medicaid Act in the Eighth Circuit, there is arguably no private right of action to do so. If you want to sue under the Voting Rights Act, even Section 2, we had some wild Eighth Circuit judges saying there is no private right of action to do that. You have the restriction on discrimination jurisprudence, like in Title VI, your only private right of action is for intentional discrimination and not disparate impact. So, I mean, just so that there's context against which people are legislating, it's disappearing ability to go to court under existing theories. So, you know, that private right of action is vital to any sort of legislative effort. And pardon me for interrupting you, Grant, but I hope
very
the context is helpful there. Yeah.
Yeah, and it feeds into the next point, which is that I think the private right of action is only bolstered by strong transparency and accountability provisions, right? If someone cannot effectively make a claim in court if they don't have the information they need to support that complaint. And so transparency, similar to what Upton has been describing, is key to any sort of enforcement or regulatory framework for responsible AI development and use. This covers a lot of things that the SDAA does cover, like notice when someone is being evaluated by an AI system, audits, ideally by an independent body that covers both accuracy and bias, annual impact assessments for kind of a broader range of issues that we see, like environmental impacts of more kind of sophisticated AI systems. All of these things publicly reported in a publicly available way that individuals without a technical background can understand is an incredibly powerful tool to make sure that AI developers are doing things responsibly and empowering people who are harmed to actually kind of move forward, whether that's through litigation or whether that's through an administrative proceeding or whether that's through just public outreach, press publicity, scrutiny, speaking with their congresspeople. So transparency, I think, is definitely a key aspect to any sort of responsible use here.
I think it's kind of so when you look at the act and you look at all the data that is required to be collected and you look at the volume, I think it would be hard for any entity actually to be able to demographic test that and determine whether there's any kind of inadequacies. So are you saying, Grant, in a way that you think it would be beneficial for private practitioners or experts in data analysis to have that transparency to be able to do demographic testing, perhaps?
Yeah, so there are a few different ways that the audit and transparency requirement can work. And a lot of federal agencies are actually thinking about this too. Back in January, the NIST released an AI risk management framework that in part has a very, very fleshed out testing and evaluation scheme in play. And so what do we mean when we talk about audits? Well, first and foremost, I love the overlapping framework. So kind of a yes and situation. I think developers of AI systems should be doing this testing firsthand. And Epic believes in this zero trust AI governance framework. So we don't trust them to do it well. Let's have some independent auditors come in as well. And there are some companies that do exist already to do that. Also a fan of empowering government agencies to take that on themselves. What does the audit ideally include? Well, sometimes it's as simple as a data audit. Hey, let's look at the data that you're using to train the system and see if there are any clear cases where it's unrepresentative for the uses that you're using for. Whether there are some clear indications that there is biased data here, whether there are proxy variables that could be used for bias. For example, we often see things like zip codes being used for seemingly objective determinations about someone's ability to do X, Y, and Z, eligibility for a certain program. When in reality, a lot of zip codes perpetuate sort of historical biases through traditional redlining practices. And so oftentimes the audit is taking a step back and looking at what the data is actually injecting into an AI model. But it's also looking at stress testing the system. If you are using it for an important government function or important commercial function like hiring or provision of medical benefits, you should test the system under conditions where you might see those people and see if it's actually producing sort of biased output. So there is a whole kind of conversation we can get into in what auditing and risk assessments might look like. But there are independent auditors that are already doing this. There are companies that have already taken on obligations to do this. Recently, 15 companies actually made voluntary commitments to the Biden White House to take this on with their very complex generative AI systems. So the transparency prong is still actively moving forward. Obviously, the resource question is an important one, but it isn't one that I think isn't insurmountable.
And I think when it comes to algorithmic decision making, it scales so quickly and it's so quick and just in general. The due process consideration when you don't have an independent auditor able to kind of regularly view that pool of data that they're using could actually harm people, in a way that people wouldn't even be aware of and at pace, at a very large scale. Sorry to cut this short, but I wanted to move into talking about third-party vendors. And obviously anybody in the panel could basically discuss this, but how do you see the role of third-party vendors and how somebody like a body like OAG could hold them accountable when it's their algorithmic tool that's actually doing the decision-making that's then provided to a DC agency or a government agency in general? Where's the status of the law on that? And how do you think there's a way to combat or maybe hold those groups accountable as well?
Sure. I'll keep this brief because I know there are other panelists with some really great insights. And Kevin, I know you also have worked against a lot of the vendors that I've been researching, so I'm sure you have some insights too. Recently, my organization, Epic, published a report specifically on state AI procurement. And so one of the paths forward that we found most useful is actually in procurement reform. A lot of the substantive AI oversight bills have been facing a lot of pushback in Congress, particularly from legislators who really do believe in the kind of AI as important innovation narrative and don't think that any sort of restriction of that is valuable. Procurement is an easy way to get around that. Procurement officials can do a lot when negotiating contracts with vendors to protect and ensure protections for consumers and impacted communities. So we looked at a lot of contracts, about 620 of them, and found a few examples of good procurement language. So things like increased data controls and ownership to make sure that vendors don't retain government information about consumers for any purposes outside of the scope of the contract, that there are some sort of independent audits built into contracts, which we actually have seen some agencies do, and other things like requiring certain sunsetting provisions that vendors often abuse for 10 to 20-year contracts that really lock an agency in to a really, really costly kind of vendor relationship, even when their systems are failing to meet the needs that they set out for in the contracts. So that's kind of one path forward. Generally, though, we have seen agencies in every single state in the country turn to private vendors for some sort of AI decision making. Often, I think as we've referenced today, they fall into three buckets. One is kind of eligibility screening, one is fraud detection, and the other, more recently, is generative AI issue, AI chatbots, automated notices to claimants and things like that. And every single one of those instances, we see the same kind of issues raised of potential errors, potential bias, and accountability gaps where government officials don't have the knowledge, the training, the access to actually meaningfully look at the systems, how the systems are producing their outputs, and make sure that they actually don't do any harm. So I'll get off my procurement pedestal here, and I'll put a link to the whole report in the chat and let the other speakers speak.
Oh, I put one in there. I put the screen report for DC for Epic. I put that in the chat already for you. But so Kevin, did you want to touch on any of that? And also, one thing that I would really love to hear your opinion on, and obviously you can choose to discuss it if you'd like or not, is if you were looking at like the EPD waiver, the inter RI tool right now in DC, what do you think would be your strategy in terms of hoping to undertake that, and maybe try to adjust it for the residents here?
Yeah. On the vendor thing, and I'm curious to hear how it's working in private sector stuff too, in Sam's case. So on the government front, we have to recognize that, you know, a lot of state and local governments have been hollowed out very intentionally over years, right? That's been a part of a political project and also part of, you know, economic changes and vagaries and all that stuff. But you have diminished capacity in some ways. So you have vendors acting as vultures that come in to associations of state government stuff that say, hey, look, we've got this great product that'll enable you to maximize your manpower, right, and your staff power and all of these things. And assume that officials have good faith. They're like, oh, that sounds great. Like, let's go use this thing. And then they don't have the technical capacity, knowledge, institutional memory to ask good questions of it, to build good contracts, to think through all those things. You also have to account for bad faith. And this is an account of Arkansas, that governments are oftentimes perfectly happy to have weaponized systems, like systems that don't work well, that aren't designed well, that whatever, like hurt people. That was, I think, a place for me that was intellectually a little bit hard to reach until I worked in legal aid and understood how much, you know, ill intent is out there, right? Like actively bad stuff. Vendors, I don't think have much shame, and I don't think they have terrible amount of pride in their work. You know, I feel like at some point we're going to get sued for defamation, but as long as I keep to the facts, that, for example, in Rhode Island hired Deloitte to build its eligibility system for SNAP and Medicaid, like to make the application process supposedly more easy. And it didn't happen. Nobody got SNAP benefits for months. And Rhode Island's AG ended up suing Deloitte and forcing some changes there. That's one of the few instances where a state has actually taken action against their vendor. For most states, the incentives just aren't there to do it. It's like, what are you going to do? What are you going to go back to? You're in a path-dependent situation now. You've used a new system. You've gotten rid of your capacity to go back to the old system. How are you going to administer these vital functions without it? You've got concerns that these vendors do a lot of other things for you. So if you attack them on this, will you damage your relationships with them for these other secondary functions? You've got the fact that then that would be admitting huge mistakes on your point, and maybe there's repercussions there. So vendors operate with relative impunity. And I think one of the next steps in terms of algorithmic accountability work is taking them to task, whether that's the shaming mechanisms, whether that's litigation mechanisms, and there's some state actor theories that you can get them if they're doing vital government functions. And they generally have less immunity that way than like a state official does with qualified immunity. So I think that's one of the next fronts in this stuff.
Can I?
Oh, sorry, go ahead.
I'll briefly add to your point about taking vendors to task. This is the point that I'm really, really interested in hearing others' perspectives on. At Epic, for example, we've been thinking about submitting administrative complaints to agencies like FTC and DOJ. to look directly into vendors and try to use their authority creatively to get at some of the issues we're seeing when direct litigation often has to get through an agency on the public sector side.
Yeah, I think related to that, you know, the EEOC and HHS, as well as HUD, all have had and are undergoing separate considerations of what does it mean in this world with their screening algorithms under existing civil rights law. And I guess related to the private market, I think there are a couple of takeaways. The first is that, unsurprisingly, you know, these third-party agencies try to pass the buck on to the landlord or to the employer in the employment context and say, look, I'm a tool that's being used and, you know, I can't be held liable for that. And in terms of litigation strategies in my past work, what we've always done is to name both parties as defendants. Eventually they turn the finger on each other, and depending on how you pursue your strategy is you can get some really interesting and helpful evidence there. So I will say, I think in general, pointing the finger is a bad strategy, especially when you have a co-defendant who can flip on you a little bit. But there are workarounds that way. And I'll say too, and I think this is just echoing what's already been said about how third-party vendors perceive their liability under these statutes. So under the FHA in particular, because disparate impact liability wasn't very clear until 2015, like at trial last year in 2020, we had high up representatives from CoreLogic saying that no one in the company thought that they were, you know, able to be held liable for anything under the FHA. They just full sail like disclaim liability, even though they're making decisions that really cleanly fall under the FHA. And the FHA, compared to a lot of other statutes, it's really clear in its legislative history that it's meant to have a sweeping scope. It's meant to target discrimination overall. It's not meant to target a specific entity doing that discrimination. But that being said, because this is relatively recent, that decision coming out of the District of Connecticut is going to be the first deciding if a third party can be held liable under this theory for the FHA. And then the District of Massachusetts case is following. But all of that's just to say, this is a really new area of law. And when the law isn't clear that it applies to third party vendors, unsurprisingly, they try to pass the buck, and they try to pass the buck hard.
I'll actually take this as an opportunity to get insight either from the panelists or anyone in the audience who has thoughts. So, right, the Stop Discrimination by Algorithms Act is not a done deal. It is just a bill sitting not so far from Capitol Hill, but it's in the Wilson Building where the council meets. And one of the major issues that came up when the bill was heard last year, and that will have to be resolved if the bill moves forward this year, was about where liability lies. Is it with the developer of the technology and tool or the deployer of the technology and tool, right? Is it the people who know kind of all the special sauce that went in to the algorithm, or is it the hospital system or the HR manager or the apartment building that's using this tool without any knowledge of kind of what's going on underneath the hood? And not surprisingly, developers of these technologies said, right, it's the end user who should be holding the bag. And the end user said, we don't know what's in this thing. It's the designer and developer who should be holding the bag. And I think the Stop Discrimination by Algorithms Act tries to work around that by allowing those two parties in the process to contract with one another for who's going to be responsible for what parts of the audit and what parts of the information gathering and sharing. But I don't think it necessarily allows them to contract around liability ultimately. But just this question about where does that rest? Where does that responsibility rest? At whose feet? I think is probably going to come down to who has more organized, you know, vociferous representatives in the lobbying process. But I'm curious what you all think is the right answer to the question of how do we allocate responsibility if we do have the chance to make that express in the statute.
I might prod you a bit on whether we need to choose. So we've worked with a few state legislatures. One that I will mention is the New York State Senator Brad Hoylman-Segal is proposing an AI employment bill that actually has joint and several liability, where you can sue both of them, one of them. They are both responsible. And similar to what Sam was saying about having the parties point at each other during litigation, joint and several liability, while it sounds kind of extreme in the front end, forces these end users to take the steps to make sure that they're doing things responsibly at the outset, and making sure that the developers are actually providing that information before harm occurs. We'll see if that's actually how it works in practice, but definitely an option available to us.
Yeah, I was going to add, and this shows my bend as a plaintiff's lawyer, obviously, but why not both, right? The idea is under the FHA that we're supposed to not discriminate and prohibit in ways that make it difficult for marginalized folks historically to get housing. And I think that you can say that both a landlord or a housing provider, as well as the third-party tenant screening company, have responsibility here. And I also think, echoing the comment earlier in Grant's addition to it, that the pointing the finger process is necessary to get a lot of really good discovery, right? Otherwise, it's, possible to hide records at one party that isn't going to be held liable. Like, there's some ways around that, obviously, with different discovery processes and procedures. But that's just to say, I think that the process of having both the housing provider and the tenant screening party or the whatever third party vendor be liable is really helpful in just making sure that those two parties actually solve this issue and don't wash their hands of it.
Just something I'm just curious for the group. So what I've read about when third parties who develop these algorithms are kind of pointing the finger, they say, we are like a hardware store, we're selling you a hammer, we shouldn't be responsible for how you use the hammer. How would you kind of like respond? Obviously the hammer would be essential to any crime that is committed using the hammer, but I just wanted to get your thoughts on that kind of reductionist argument.
I think it's flawed for a lot of reasons. I think the better comparison would say that you're vending a hot dog saying it's beef, but you didn't make the hot dog at all. You're just giving it to someone and hoping that if they want to avoid the beef, that you're right, that whatever was given to you is a beef hot dog, and you're conveying that information appropriately. You don't go and buy a hammer and then wonder what a hammer is, what it could be used for, what came into the hammer, how the hammer is going to decide how the project progresses. There's a lot of, decisions that are made by algorithmic screening processes, and those decision points aren't analogous to just someone using something as a means to an end.
Yeah, and also they're trying to keep the manufacturing process of the hammer a secret, right? Like, which is something that I think also is bad there. I'm really curious about the vendor liability question in the private kind of contract sense, because of how vital it is in the public sense, right? So much of the way we can get at this stuff through existing jurisprudence is discrimination or due process. Discrimination or APA. No damages in APA. Discrimination, maybe damages, but narrowing, right? Cummings, and again, it's another part and parcel of this whole restricting access to federal court stuff. And then you go through due process and you can only get prospective injunctive relief, right? Again, unless you pierce qualified immunity, which I think everybody should keep in mind. It's great, but it's not going to be available in every situation where there's due process failings. So there's no way to change the incentive structures for governments or vendors to get this right under existing jurisprudence. So the only way we can alter those incentive structures is with vendor liability. That'll do something. As well as if we get new causes of action that expressly authorize damages against government entities that use these things that apparently would be premised on, the fact that they're using an algorithm as opposed to whatever the substantive law we'd otherwise use would be.
So the way it kind of is just like so interesting to me is like, if you're using something that's just absolutely not germane. So like if you're looking at like a criminal record, and you're making a health determination through DHCF, like that's not even germane to the question you're trying to answer, right? So by nature, it's predatory. I would agree with you, Kevin, and say that I feel like that I don't think you could ever create a list that says this is what you can use, but I definitely think for specific decision-making processes, you can eliminate very specific things that you shouldn't be able to use, if that makes sense.
Yeah, it totally makes sense. And we think about this in terms of rationality, like almost like a fit, like what goes into the algorithm that you're using, and is there a way to challenge sort of the rationality of it? An example with rugs, this home care tool stuff, is they ask you 286 questions on the InterRAI assessment. Of those, only 60 ever matter. Those 60 don't always matter in the same way. Sometimes it's only 8 of them that matter. Sometimes it's 12, sometimes whatever. So they're asking you a whole bunch of irrelevant information. Some of the information that they do ask you that does matter doesn't seem to have any correlation to how much care somebody needs. For example, did you vomit in the last 3 days? Why is that relevant when whether or not you can walk unassisted is not relevant, right? Like there's just all these weird permutations of how algorithms work that don't make sense to us. And those get more complicated the more machine learning you get, right? So how do you challenge like the idea of the rationality of it? And that's an interesting piece, and there's not a clear way. The federal APA provides, kind of the arbitrary capricious review for a rule. Our judge in our state APA claim was not willing to go there. It wasn't explicitly in our state APA, but we have a kind of corollary state action that gets at arbitrary capricious. But he was like, look, it's not my job as a judge to review an action of the executive agency as long as they adopt it, with proper notice and comment, regardless of how irrational it is. And then there's people out there who think that like the due process clause provides an overarching sort of check on, arbitrary and capricious action, but that's had a lot of negative jurisprudence in it out of the DC circuit. So I think that's a question like, how do you get sort of at that rationality question? Bardia is great. I don't know the answer.
On that note, I wanted, and apologies for not being on video, this is my dinner break in the middle of writing a motion. So, but I wanted to bump what I put in the chat about HHS promulgating a new rule that would ban medical decisions from being made based on, among other things, on the belief that someone who is disabled, their life has less value than someone who is not disabled. I was really floored when I saw that because I was kind of shocked that that was not so obviously disability discrimination that it wouldn't need to be said, but evidently it does. But I think kind of to that end, I agree that I think a kind of joint and several approach is probably the best, because on one hand, I think that people who develop an algorithm are by far in the best place to like know what is going into that, to like test it, to see if like different inputs are going to have like disparate impacts, stuff like that. Like I think the people developing an algorithm are definitely best suited to kind of on the front end do the most that they can to prevent stuff like that from happening. But I also think that, if you are a landlord or an HR professional or whatever, like you really have no business using an algorithm to make those kind of really critical determinations if you don't understand what's going into it, or at least are not aware and assuming knowingly the risks of using that algorithm. So I think kind of on it doing it in a joint and several way kind of gets you at the like front end, providing an incentive to do thorough research, and also on like kind of the back end, like don't let people get out of the repercussions of using an algorithm just because they weren't the ones who wrote it.
Sebastian, do you want to take the next step?
Sure. So that's a great point. I think given that we are kind of in DC, at least, like algorithms are used privately and in DC government agencies, it's pretty widespread, it's convenient, it's easy to use. What I was trying to understand, at least in the fair housing space, like how can we ensure that companies like Safe Rent and Rent Grow can still be used by landlords, but do so in compliance with existing?
Yeah, that's a good question. And I think too, to add to the backdrop, like we're in a slippery slope where these screens are happening. They will continue to happen. In my mind, it's a question of how do we make the screening process fair and equitable and actually reflect, the metrics with which they're trying to reflect. Because I think tenant screening is a great example. Tenant screening platforms of various kinds are used by the vast majority of large landlords in this country, just because they can't go through the paper backlog of applications. There's an efficiency value there. And I think that, folks often on the other side of the V from me really focus on that efficiency angle. And I think that that's fair, right? The idea that we theoretically have technology that's going to be able to, do these checks shouldn't be an inherently bad thing. It's when those technologies and those checks are, contravening existing civil rights laws, existing fair housing laws, existing, data of what we know is predictive of someone being a good renter, for example, when it becomes problematic. So I think in the DC context, the way that the FHA is the most applicable is large private landlords, right? That have these screens that often don't know the secret sauce behind them. So for example, in the both SafeRent and CoreLogic, because the documents from the parent company were the same, it was really clear that absolutely no housing provider, no one at any point of their, chain of command knew what the inputs were that went into these screening tools. So even if they wanted to be informed, like, let's try to be charitable here and assume that, a landlord really wants to do right by their tenants, wants to do right by the law, is assuming that by getting what they see as an objective third-party screener, they think that they're doing that, right? They think that by putting something to the machine that's less biased than human error. And I think that's the contour that really needs to be developed and is interesting to see as it relates to DC in particular, as it relates to the FHA, right? What are we going to do so that these products don't produce a disparate impact for marginalized communities? In particular, easy examples. We know that products that consider criminal background checks, especially those that consider arrests as well as convictions, are really disproportionately excluding folks of color for, things that aren't predictive of their ability to be good renters. And I think that because these products are so widespread, and especially at larger private landlords, there's really a lot of room to listen to folks on the ground about their lived experience and figure out, hey, you applied for this apartment and didn't get it. Why? What do you think happened? Were you given a letter that said that someone else considered your score? Because also under the Fair Credit Reporting Act, a lot of folks should be getting notices that, something is a reason why they were denied, especially if it was credit related. And these products, in my past experience, have a lot of form letters just saying, hey, you're denied because you didn't pass, the SafeRent scoring algorithm. It doesn't delineate what criteria you didn't pass. It didn't delineate what piece of your history was problematic. For example, if you had, several things in your criminal history, it doesn't say which of those led to your exclusion from a property. And I think that there's a lot of room in trying to make transparency and contours. But if we listen to folks on the ground, I think we'll learn a lot about, where folks are running into issues and they're being excluded.
To quickly add on to that tenant screening issue, even if you are someone on the ground who knows that a tenant screening report has made an error, and you go to a RentGrow, a SafeRent, a CoreLogic to correct that error, most times it will be a non-durable correction, which means that the next time that they purchase data from a data broker, a commercial data set, that error is imputed right back into their system, and the same issue is going to pop up the next time you have to go through the system. So we, after publishing our screened and scored report last fall, got an influx of messages from people saying that they had been denied several occasions over 2-3 years, even after going through hoops of trying to correct it with every single person, every single entity they could find, because every time they found something to correct, some other party would purchase the incorrect data from a data broker, and the whole process would go over again. So to kind of add on that, it's not just understanding the issue, it's not just trying to correct the issue, it's making sure that the changes are durable, if they persist, and that there's an accountability mechanism there.
I have a question. It's for the panelists, Bardia, Sebastian, everybody, if anybody can entertain it, or maybe it's a long-term thing. I am leery of putting so much of the discourse into the anti-discrimination framework because discrimination claims are so hard to bring and sustain. And you will be able to have governments, private actors, or vendors develop things that are not discriminatory, but are still super harmful, right? Like, okay, it discriminates against everybody equally, right? Or it treats everybody equally badly. And so I'm wondering if there's been thoughts outside of kind of procedural stuff, due process, Fair Credit Reporting Act, things like this, um, to restrain algorithms in ways that aren't dependent on the discrimination or procedural regimes. I mean, maybe it's just outright banning them, like certain tier, like Canada's tiering system. But if it was associated with bans or things like that, I'm just wondering if anybody has any knowledge of that or interest in that.
I'll throw one example out there. Sam talked a lot about the Fair Credit Reporting Act, and I think there is a lot going there that is still kind of yet to be finalized, particularly when it comes to companies that are providing AI tools to make reports that, in my opinion, could be deemed as consumer credit reports under the Act. A lot of these companies kind of disclaim any sort of responsibility as a CRA or a consumer reporting agency, disclaiming any obligations under the Fair Credit Reporting Act. But for example, if they are a CRA under the Act and a consumer tells them that there is an inaccuracy or an incompleteness in their file about them, they have to reinvestigate that and they have to notify the consumer and also the other users that have been providing that data to them. So there are a lot of additional obligations on the kind of consumer financial side of things that I think could be ported over to a lot of the companies that are providing AI tools. Not all of them, there's definitely some wiggle room here. There's a gray area, but would love to see more exploration of that.
Yeah, and I'll echo that. I think that the Fair Credit Reporting Act claims are some of the ones that have not been litigated as much, but have a really fruitful ground to litigate upon. Understanding the context of the law and everything going into the statute and different relevant definitions, they're strong arguments. And there are Fair Credit Reporting Act claims in Safe Rent. The facts of the situation made it a little messy, but we'll see what ends up happening when push comes to shove and that decision comes out. But I just wanted to add that I think that unfair and deceptive trade practices statutes, both at the federal and state level, are really helpful for addressing, this gray area of it's unfair, it's not okay, but it's not stereotypical anti-discrimination. And I think that there's some teeth there that I've explored a little, but there's more room to explore, definitely.
Yeah, Sam, I would second that. I was going to say that UDAP laws are really powerful and all-encompassing. At least in the district, our law has been interpreted very generously. I recognize that in maybe some other parts of the country, consumer law has been constrained a bit more than we would like, but I think it doesn't have all of the same kind of warning lights flashing around it for folks to try to curtail its use in the same ways that some anti-discrimination law does. And so perhaps there's more sort of bipartisan support for preserving the strength of consumer law.
Sebastian, did you want to open it up for maybe some Q&A if anybody wanted to?
Yeah, for sure. Thank you everyone for this very rich discussion on AI. If there's any questions, Chris, do we have any questions through the chat?
I don't see any specifically in the chat, but if anybody has any questions that they would like to ask, feel free to come off mute or add them to the chat.
I wanted to tie something together quickly. So Grant, in your Epic report, there was a vignette about a person named Juan who basically had something in their rent grow report that was wrong, right? So they went to basically try to correct it. And by the time that they were trying to get that apartment in DC, which we all know housing scarcity in DC is just a nightmare, the apartment had been rented. So basically what it was is a due process violation that there was no fix for because the apartment's gone. There's really nothing you can do. But I think that entire vignette kind of underscored the whole point behind having that data that's gathered by OAG be able to be tested or evaluated by kind of private experts, because these decisions occur so quickly that like if people aren't kind of monitoring and testing the pool from time to time, then we might not even know that these things are happening before the harm already occurs, and then there's no recourse.
Yeah. I mean, not much to add on that. Just to say, absolutely true. We've seen kind of across the country too, similar instances where we don't see the issue until it is way past the point where it's causing harm. Michigan's unemployment insurance issues are always one that I love to bring up. They purchased a system from a company called Fast Enterprises in the mid 2010s to build this system just for the Michigan Unemployment Insurance Agency called Midas. It was so bad that it actually kicked about 600,000 people off of their unemployment insurance benefits incorrectly before anyone caught it. They went through a very costly class action litigation. Kevin can probably tell you way more about that than I can. And then finally, they kind of kicked Midas and Fast Enterprises to the curb after spending tens of millions of dollars on it, and went and just contracted with Deloitte for a similar system that is causing some issues across the country still. So the issue is always kind of bubbling up to the surface only after it's caused a lot of harm. And would love to think of ideas that we could enforce these issues or litigate these issues, regulate these issues proactively before harm happens. Because too often we kind of force it on people who don't have the time, the resources to kind of devote to this the same way that a lawyer could. We're talking here because we love this issue. There are millions of people around the country, hundreds of thousands of people in DC who are facing similar issues, and they just have too much else on their plate. They can't spend their entire days trying to find justice in this one system. So yeah, it's a tough place to be. And I'm not sure what the best solution for it is.
Yeah, I mean, ultimately, I think we do see the intrinsic value of adding technology for automated decision making because it does help save resources for government entities. But I think it needs to be, Kevin, you're disagreeing, but I think if you do it in a way that is proper and regulated properly and has proper monitoring mechanisms, I think you can implement it in a way that would be helpful. You're just saying no, never. What about something for like SSI though? I mean, that's a pretty standard determination for certain people. Like if you're over certain age, and you have the certain different parameters that are met. I mean, that could like clear up a lot of admin waste for SSA, which they're having a huge problem with backlog, perhaps. I think if you really did, like, I'm not saying just like use it everywhere, but I'm saying if you really like finitely use it with proper safeguards, it could be used well. I just don't think it is right now.
And just so everybody knows, Buddy and I have talked before, so I'm giving him a hard time. But so I've thought a lot about this, and you got to watch because anybody who's on the other side of this debate will take any little inch that you give them about possible utility of it and just run with it and say, oh, okay, well, look at all the great we're doing, and it's just these few bad examples, and we'll work out the kinks. The one area I think there is legitimate and safe potential use of this stuff is in eligibility and enrollment stuff. Or taxes people use as the classic example. Like the government knows how much you earned generally. They should be able to run all this stuff and tell you what your tax bill is. For Medicaid, you provide the information about your income, or they get it through hopefully accurate data matching sources, which they have, and they can tell you that you're eligible, or they can automatically renew your eligibility. That kind of thing, I think, is where the promise is, if there is any. Even there, that stuff can be weaponized, though. Like in Medicaid or in all public benefits, churn, right? Bardia, you dealt with this before, right? People churn off the system because of paperwork burdens that are generated from bad data matching schemes and other things like that. So anyway, to your point, I think I'm much less optimistic that it can ever be used. I think the field in which it can be used potentially for good is fairly narrow. And even there's the chance that it's going to be weaponized against at least my client communities, the people I care about, which is low-income folks or people who are marginalized through other means.
I will just quickly add, they spend a lot of money for these systems too. For every argument that this is a cost-cutting measure, that this is increasing efficiency, there are hundreds of millions of dollars going to these vendors for systems that we've seen are often flawed. causing tens of millions of dollars in litigation fees, and another 10 to $100 billion to purchase another system. So when we think about AI systems in government, at least, don't forget that they cost a lot of money. The cost savings that you might get over years is it needs to be balanced on the costs that you are throwing at private vendors that could be used to improve services in-house, train people, provide direct assistance to people. So, it is complicated. I think that Kevin is right that there might be some. I think I'm honestly more cynical about it than Kevin is even. But if there is a useful purpose,
cheers.
It needs a lot going for it. You need a lot of questions when it comes to who the vendors are, what processes they're doing to make sure it's responsible, how much money they're expecting in return, everything like that.
Well, on that cheery note, Sebastian, do you want to take us out?
Let's do it. Thank you so much, everyone. This has been a great discussion. So thank you to Sam, Grant, Kevin, Kate, and Kate's baby AEG. Have a good evening. This will be this is recorded and only go out to our members, and so look for an email in the next few days. Have a good weekend, everyone.
Thank you, everyone. Thank you so much for participating.